But don't undervalue your stuff either. You do that and you risk attracting the attention of the trustee who may think you're trying to pull a fast one. A special note on home exemptions, also known as homestead exemptions.
Equity in a home is protected up to a certain amount, which varies from state to state. Equity is the difference between the value and the amount you owe. If your home is worth $200,000 and you owe $140,000, your equity is the difference of $60,000.
Homes purchased within 1,218 days before filing are limited to a cap of $125,000 in equity.
For example, Nevada allows up to $350,000 in equity as of the writing of this material. But if you purchased your home less than 1,218 days ago, you will be entitled to the cap of $125,000 maximum. If the cap in your state is less than $125,000, it remains unaffected, meaning it does not increase to $125,000 just because you bought it less than 1,218 days ago.
By the way, I have no idea why they came up with the precise number of 1,218 days. Home exemptions are also limited to $125,000 if the debtor has been convicted of a felony, is guilty of state or federal securities fraud, racketeering, or intentional torts that have caused serious bodily injury or death within 5 years of filing. Now we'll move on to Schedule D.
Schedule D, your secured creditors. Secured creditors are creditors that have a security interest in a tangible piece of property, like a home or a car. A mortgage company is a secured creditor. The mortgage is secured against the home itself. If you don't make the payments, they foreclose on your home. You must make sure that if you plan on keeping the property like your house or your car, that you must continue to make your payments on time. We recommend sending the payments by certified mail so that you have proof they've received the payment.
Some unscrupulous mortgage companies have been known to claim they did not receive payments so they can move forward with foreclosures on homes. You cannot list a secured creditor in a bankruptcy and expect to keep the property unless you make the payments. If you don't make the payment, the creditor will repossess the property. Otherwise, people will go out and buy a Lamborghini and then file bankruptcy.
Schedule E, priority creditors. Creditors that cannot simply be wiped out in bankruptcy. These include certain federal and state taxes, child support arrearages, and alimony arrearages.
As a rough guide, taxes must be at least 3 years old. You must have filed them with the IRS at least 2 years before the bankruptcy. They cannot have been assessed by the IRS within 240 days, and the taxes must not have become an IRS lien. If the taxes meet this criteria, you may be able to eliminate them without repayment.
Schedule F, unsecured creditors. Credit cards, charge cards, personal loans, bank loans, payday loans, medical bills, cell phone bills, etc. It is extremely important that you list all of your creditors on your schedules.
If a creditor is not listed, it will not be discharged, and that creditor will still be able to pursue you after your bankruptcy is over. You must also serve the creditor notice.
Hi, this is Mr. Smith. Just want to let you guys know that I'm filing bankruptcy. Okay, you guys have a nice day. Bye.
That's not quite the way you're supposed to do it. Actually, the creditors are formally notified with the filing of the bankruptcy. You must provide the creditor with your name, your account number, and the approximate amount that you owe the creditor. And the creditors have to be served this information at an address that they've provided you on a recent correspondence.
As such, provide your attorney with as many recent bills as you can find. Also, make sure you list the collection agencies even if the debt is already listed under the original creditor. So, if Bob's Electronics turns the matter over to Nasty Collectors Inc., make sure you list them both. More is definitely better. List everyone that you can conceivably think of that you may owe money to. Even if you got into an accident, you're not sure whose fault it was. Still list the other driver in the bankruptcy or anyone else in the accident that might sue you, including any passengers in your own car.
Even if it is a friend or relative, blame it on your lawyer. Say your attorney required you to list all potential creditors. And actually, this is not a lie. You must list all of your creditors.
Schedule G, list of your unexpired leases or contracts, like a vehicle lease.
Keep in mind that if you list a debt for which you had a cosigner, your obligation will be discharged in the bankruptcy, but the creditor will still be able to go after good old dad because he will still be on the hook for the debt he co-signed on your behalf.
Schedule H, list of debts for which you have a cosigner. For example, if good old dad co-signed on your vehicle, you'd list that here. Schedule I, your current income of the debtors which we previously discussed. In this section, you also give marital status information, lists of dependents, and specific employment information. Schedule J. List of expenses like mortgage, rent, food, car payments, utilities, insurance, clothing, laundry expenses, gas for your vehicle, entertainment, charitable contributions, etc.
Next, we have what is known as a Statement of Financial Affairs. Basically, this is sort of a history that gives the trustee and creditors a picture of what has gone on in your financial life and life in general for the past number of years.
The statement of intentions indicates what you plan on doing with property that is secured by a loan, like your house or car.
Basically, you have two primary options. Reaffirm the debt, meaning you will keep the property and promise to make payments on it in the future. The other option is to surrender the property, not make any further payments, and not owe anything any further either. Now, under certain circumstances, you may also redeem property. This means if the trustee has the right to seize a piece of property, you may pay the value of the property to the trustee in order to keep it. The reason being is that the trustee will be able to get the same value from you for distribution to the creditors that he would have gotten from the sale of the property through an auction or outright sale.
The attorney statement is a short form that states the name of the attorney and the amount you paid for the legal services.
Those are all the critical documents.
Here's a list of some of the most commonly requested documents for which either your attorney, the trustee, or both will ask. Try to gather these documents together before you go to meet with your attorney if possible. Also, a separate certification will need to be provided showing the debtor attended a mandatory consumer credit counseling session. This session may be attended in person, telephonically, or even via the Internet. Again, check your written materials for a list of accredited consumer counseling agencies.
Regarding the credit counseling session, only agencies recognized by the Office of the United States Trustee will be accepted. Otherwise, you have just wasted your time and your money on a useless certification. You must also provide a notice of any changes to your existing income expected within 180 days of filing, as well as pay stubs for the 60 days prior to filing your bankruptcy.
The first thing is the automatic stay. The automatic stay makes it a violation of federal law for any of your creditors to pursue any remedies against you, including filing a lawsuit, continuing an existing lawsuit, sending you letters requesting money, or even calling you on the telephone.
A creditor violating this rule may be brought before the court and sanctioned. However, a creditor can also file a motion with the court to get permission to continue to pursue you. This typically happens if you are delinquent on your payments on a house, car, or other secured loan.